Talk shoes. Recorded live.
Good evening, everyone. This is Matthew. It's 7:05 Central Time, 8:05 Eastern Time. This is the regularly scheduled The Free Americans Talk Shoe Group with special guest Christian Walters. And before we get started, I'll go ahead and read our disclaimer. This show and our documents is private and not to be construed or relied upon as being legal advice for any individual legal situation or employed for making legal decisions. You will not use any of this information for making a legal decision or performing a legal procedure. It is not a substitute for legal advice and or guidance by a licensed attorney. This show and our documents are for academic informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing and reviewing the show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of the herein reference, and has no interest in any issue referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaison of communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and our show recordings are incomplete and void without this notice agreement being attached herein by reference and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million per or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. And with that said, I'd like to turn it over to Christian. Christian, you have the floor.
Okay, thanks, Matt. How am I coming in?
You sound great.
All right, as Matt said, we're starting a new book today. The book title is A Practical Treatise on the Law of Trust, and it's by Thomas Lewin, Esquire, and it's the 8th edition by Frederick A. Lewin. And this is the first American from the 8th English edition. I guess it says it's by James H. Flint. This is Volume 1. It's a Boston, Charles H. Edison and Company Publishers, 1888. So again, the title of it is A Practical Treatise on the Law of Trust by Lewin. First volume, 1888. So now the preface to the American edition, it says the accurate and exhaustive treatise of Mr. Lewin can receive no warmer nor more effective communication than that which voluntarily or unconsciously falls from the lips of every reader. The English cases have been brought down to date, and this part of the work has been excellently done by F.F. Hurd, Esquire. The text has been modified and corrected as indicated by the agenda et corrigenda of the 8th English edition. In the American notes, the attempt has been made to show the difference between English and American decisions, to cite the leading cases upon the subjects treated, and to briefly indicate the substance of the decisions. To know where knowledge is next to having it. And if the reader finds his attention directed to such cases as he seeks, his perusal of them renders any lengthy abstracts or quotations unnecessary. Insofar as these annotations are found numerous, accurate, and comprehensive enough to afford any assistance, to that extent it will be felt that this labor has not been in vain. And that's by J.H.F., Boston, in May 1988, when he wrote that. Now the preface. Since the publication of the last edition of this work, several important acts of Parliament have been passed, which have given rise to numerous and in many cases fundamental changes in the laws effectuating the relative positions of trustees and their cestui trust, and their respective rights and powers. These, together with continual modifications in the law arising from the flow of cases through the courts, have caused a considerable increase in the size of the present edition. One new chapter and an additional section to another chapter have been introduced, pointing out the principal provisions of the Settled Land Acts as they affect the law of trust. but a general consideration of these acts does not seem to fall within the purview of the present work. With the above exception, I have not altered the form of the work, but while dealing with the late Conveyancing Act and the Married Woman's Property Act of 1882 and other variations of the law which have arisen since the last edition, I have endeavored as far as possible to weave the new matter in and make it harmonize with the previous text. An important feature in the present edition is the index, which has been remodeled and which has been enlarged by Mr. C.C.M. Dale of the Chancery Bar, whose skill in his works is well known, and to whom I am much indebted for the care and labor which he has bestowed upon it. As in the previous edition, the matter introduced by the present editor is distinguished by being enclosed in square brackets. The agenda are again considerable, but it is not possible to avoid this without passing over important decisions reported while the work was in press. That was in August 1885. That was F.A.L. that wrote that. All right, it's broken up into two volumes. The first volume is part 1. Well, actually, it's the introduction to the view of the rise and progress of trust. We'll start there. The contents, you can look through that yourself. There might be some interesting things in there. You might want to jump to those spots. Then there's the tabular analysis, where it says the references are to the star paging. And it's part 1, where they give you a little graph there. I'd study through that, and then the star would take you to the places in the book where it's making reference to that. It's like a flow chart. Part 2, continuing on the tabular analysis, kind of breaks it down into a model form. Then there's part 3, talks about the City Key Trust. And then down at the bottom of that page, it's part 4, which I draw your attention to, which is the practice in reference to the law of trust. That's part 4 on the bottom of that part 3. And it's just making references to distinguish on page 970 and production of documents on page 975 and compulsory payment into court on page 976 and receivership on page 982 and cost of suit on page 983 or 985. I can't quite read that, but now why would I make reference to that? Because that gives you more or less the practice or the practical guide in reference to the law of trust, or taking the doctrine and what you're going to do to put it into practice. So that would be the practical application parts. So now we get to the introduction. You might want to have your Black's Law, and there are some arcane terms in here, and it may take a while to get a grasp of those terms, but eventually it soaks in. So this is the introductory view of the rise and progress of trust. So this is the rise and how they progressed into the modern day trust. Number 1, first paragraph here is the origin of trust. The origins of trust, or rather the adaptations of them to the English law, may be traced in part at least to the ingenuity of fraud. By the interposition of the trustee, the debtor, thought to have withdrawn his property out of the reach of his creditor, the freeholder to intercept the fruits of tenure from the lord of whom the lands were held, and the body ecclesiastic to evade the restrictions directed against the growing wealth of the church by the statutes of Mortmain. Another inducement to the adaptation of the new device was the natural anxiety of mankind to acquire that free power of alienation and settlement of their estates, which by the narrow policy of the common law they had hitherto been prevented from exercising. Next paragraph heading is the subpoena. Originally, the only pledge for the due exception to the trust was the faith and integrity of the trustee. But the mere feeling of honor proving, as was likely when opposed to self-interest, an extremely precarious security, John Walton, Bishop of Salisbury, who was Lord Keeper in the reign of Richard II, originated the writ of subpoena, by which the trustee was liable to be summoned into chancery and compelled upon answer upon oath the allegations of his sedicii trust. And no sooner was this protection extended than half the lands of the kingdom became vested in fiat uses, as trusts were then called. Thus, in the words of the old chancellor, the parents of the trust were fraud and fear, and the court of conscience was the nurse. Now, trust simple or special. Simple trust defined. Of trust, there were two kinds, the simple trust and the special trust. The simple trust was defined in the legal phraseology to be, quote, a confidence not issuing out of the land, but as a thing, collateral, annexed in privity to the estate of the land, and to the person touching the land, solicitous that sedicii use should take the profit and that the terra tenant should execute an estate as he should direct. In order to rightly understand what was meant by this rather technical description, we shall briefly consider the principles that were recognized by courts of equity, for these had the exclusive jurisdiction of trusts. First, with reference to the terra tenant or the fiat uses, and second, with the reference to the beneficial proprietor or the sedicii use. Confidence in the person. With respect to the fiat uses, it was first held to be absolutely indispensable that there should be confidence in the person and privity of estate. For want of the requisite of personal confidence, it was ruled that a corporation could not stand seized to a use, for how, it was said, could a corporation be capable of confidence when it had not a soul? Nor was it competent for the king to sustain the character of trustee, for it was thought inconsistent with his high prerogative that he should be made responsible to his own subject for the due administration of the estate. And originally the subpoena lay against the trustee himself only, and could not have been sued against either his heir or assign, for the confidence was declared to be personal, and not to accompany the devolution of the property. But the doctrine of the court in this respect was subsequently put on a more liberal footing, and it became held that the heir and assign should be liable to the execution of the use. An exception, however, was still made in favor of a purchaser for valuable consideration not affected by notice. Now, privity of estate. The meaning of privity of estate may be best illustrated by an example. Had a fiat been made to A for life to use, or to his own use, with remainder to B and fee to the use of C, then A had an off D in fee in this case, though D had the land by fiatment, which then operated as a tortuous conveyance. Yet as he did not take the identical estate in the land to which the use in favor of C was attached, he was not bound by C's equitable claim. And by the same rule, neither tenant by the courtesy, nor tenant in dower, nor tenant by illegit was liable to the execution of the use, for their interests were new and original estates, and could not be said to have been impressed with the use. So the lord, who was in by his cheat, a deceiver, a baiter, and an intruder, were not amenable to the subpoena, for the first claim by title paramount to the creation of the use, and the three last were seized of the tortuous estate and held adversely to the fiat uses. And now privity as regards to sedicii use. With respect to the sedicii use, the principle upon which the whole estate depended was also that in the legal language was denominated privity. Thus, on the death of the original sedicii use, the right to sue the subpoena was held to descend indeed to the heir on the ground of a Latin term here, heros edendum persona cum intestator. But the wife of the sedicii use or the husband of the fem sedicii use and the judgment creditor were not admitted to the same privilege, for their respective claims were founded not on privity with the person of the sedicii use, but on the course of law. And for the like reason, the use was not assets, was not subject to forfeiture, and on failure of heirs in inheritable line, did not escheat to the Lord. Special trust defined now. The special trust, for hereto we have spoken of the simple trust only, was where the conveyance to the trustee was to answer some particular and specific purpose, as upon trust to reconvey in order to change the line of descendant, upon trust to sell for payment of debts. The special trust, the duty of the trustee was not, as in the simple trust, of a mere passive description, but imposed upon him the obligation of exerting himself in some active character for the accomplishment of the object for which the trust was created. In case the trustee neglected his duty, the City Key Trust was entitled to file a bill in Chancery and compel him to proceed in the execution of his office. And now trust applicable to chattels. Both the simple trust and the special trust were applicable to chattels, real and personal, as well as to freeholds. But trusts of chattel were, for obvious reasons, much less frequently employed. The amount of the property was small, and the owner, even without the interposition of the trustee, had the fullest control and dominion over it, and the chattel interest, as it followed the person, was equally subject to forfeiture, whether in the custody of a trustee or in the hands of the beneficial proprietor. But to the extent, whatever it was, to which trusts of chattel were adopted, they were administered upon the same principles, mutandis, as were trusts of freeholds, and the right to sue a subpoena turned equally on privity. And the interest of the City Key Trust was held not to be assignable. Next section, statutes affecting trusts. Such was the nature of trust as they stood at common law, but the manifold frauds and mischiefs to which the new system gave occasion, particularly the great usury, unsurety, and trouble arising thereby to purchasers, called loudly from time to time for the enactment of remedial statutes. One of the most important of these was the first King Richard III, number 1, Section 1, which the substance of which may well be expressed in the terms of the preamble, where, quote, all acts made or against the City Key use should be as against him, his heirs, and fiefs and trust, unquote. In other words, that all dealings with the City Key use with the trust property should have precisely the same legal operation as if the City Key use had himself possessed the legal ownership. To what interest the legislature intended this statute to apply was not on all hands been agreed. The fiefment fee to uses was clearly the case primarily intended. Upon a fiefment entail, it seems no use could have been declared, for the tenant entail was incapacitated by the statute Didonis from executing estate. With respect to the fiefment for life to uses, there appears to be no reason upon principle, except so far as the language of the Act may be thought to furnish any inference, and certainly there is no objection to the score of authority, why the City Key use might not have passed the legal estate by virtue of statutory power. It has been contended by Mr. Sanders that on a fiefment for life, no use grafted on the life estate could have been declared on a ground that as the tenant for life held of the reversionaire, the consideration of tenure would have conferred a title to the beneficial interest on the tenant for life himself. But this reasoning can have no application where the estate for life was not created, but was merely transferred. For then the assignment of the life estate was not distinguishable in this respect from the conveyance of the fee, and in such cases there is no consideration of tenure as between the grantor and grantee, but in each case the services incident to tenure were due from the grantee to a third person. And see footnote 1 there. It is clear that the statute embraces uses of lands only and did not extend either to special trusts or to trust of chattels, not to special trust, because trustees combined in themselves both the legal estate and the use, though compelled by Chancery to direct them to a particular purpose and not to trust of chattel, because the preamble and the statute were addressed to City Key to Use and his heirs and to feoffees in trust. Next section, 27 Henry VIII, Section 10. The mischiefs of the system increasing more and more, the statute of Richard occasioning still greater evils than it remedied from the facility it gave to City Key to Use and his feoffee, who had now each the power of passing the estate, of defrauding by collusion the bona fide purchaser. The legislature again interposed its authority by 27 Henry VIII, Section 10, and thereby annihilated uses as regard their fiduciary character by enacting that, quote, where any person stood seized of any hereditaments to the use, confidence, or trust of any other person or of any body politic, such person or body politic as had any such use, confidence, or trust should be deemed in lawful season of the hereditaments in such like estates as there had in use, trust, or confidence. See number 1. Next section, special trust and trust of chattels accepted from the statute. Uses by the operation of the statute became merged in the legal estate, but special trust and trust of chattels were not within the purview of the Act, the former because the use as well as the legal interest was in the trustee, and the latter because the termor is said to be possessed and not to be the judges by their construction of the statute created a novel kind of interest since distinguished and now known in the name of the trust. Before the statute of Henry VIII, a person to have had the complete ownership must have united the possession of the land and the use of the profits. The possession and the use were even at common law recognized as distinct interests, though the City Key to Use was left to Chancery for his remedy. On a feoffment to A to the use of B to the use of C, the possession was in A and the use in B, and the limitation over to C was disregarded as surplusages. When the statute of Henry VIII was passed, it executed the estate in B by annexing the possession to the use, but having thus become functus officio, it did not, as the Act was construed, affect the use over to C. However, Chancery, now that uses were converted to estates, decreed C to have a title in equity and enforced the execution of it under the name of the trust. Now, land use and trust distinguished by Lord Hardwicke. Interest in land, Hardwicke quoted, thus became 3 kinds. First, the estate in the land itself, the ancient common law fee. Secondly, the use, which was originally a creation of equity, but since the statute of uses drew the estate and the land to it, so that they were joined and made one legal estate. And thirdly, the trust, of which the common law takes no notice, but which carries the beneficial interest and profits in a court of equity, and is still a creation of that court as the use was before the statute. Now, trust not within statutes relating to uses. This newly created interest was held to be so perfectly distinct from the ancient use that the statutory provisions by which many of the mischievous of uses had been remedied, as the 19th Henry VII, Section 15, by which uses had been made liable to writs of execution, and the 26th Henry VIII, Section 13, by which they had become forfeitable to the Crown for treason, were decided to have no application. However, the trust took the likeness of the use, conforming itself to the nature of special trust and trust of chattel, which had never been disturbed by any legislative enactment. Now, trust at first modeled after the pattern of uses. To show how the principles of uses prevailed after the statute of Henry VIII, it was held in the reign of Elizabeth that the equitable term of a feme covert did not vest in the husband by survivorship, for a trust, it was said, was a thing in privity and the nature of an action, and there was no remedy for it but by writ of subpoena. And a few years after the same reign, it was resolved by all judges that a trust was a matter of privity and in the nature of a choose in action, and therefore was not assignable. And in the 6th year of King Charles I, it was decided by the judges that as a femme was dowable by the act or rule of law, and a court of equity had no jurisdiction where there was not fraud or coven, the widow of a trustee was not bound by the trust, but was entitled beneficially to her dower out of the trust estate. Next section, improvements introduced by Lord Nottingham. During the reign of Charles I and Charles II, particularly during the chancellorship of Lord Nottingham, who from the sound and comprehensive principles upon which he administered trust, has been styled the father of equity. The father of equity. The courts gradually threw off the fetters of uses and, disregarding the operation of mere technical rules, proceeded to establish trust upon the broad foundation of conformity to the course of common law. Quote, in my opinion, Lord Mansfield said, trusts were not a true foundation until Lord Nottingham held the Great Seal. But by steadily pursuing from plain principles trusts in all their consequences, and by assistance from the legislature, a noble, rational, and uniform system of law has since been raised, so that trusts are now made to answer the exigencies of families and all purposes without producing one inconvenience, fraud, or private mischief, which the statute of Henry VIII meant to avoid. Next section, alterations made in trust as regards to trustee. As to the changes that were successfully introduced, it was held with reference to the trustee that actual confidence in the person was no longer to be looked upon as essential. A body corporate, therefore, was not exempted from the writ of subpoena on the ground of incapacity, and even the king, notwithstanding his high prerogative, was invested with the character of royal trustee, although the precise mode of enforcing the trust against him was not exactly ascertained. To use the language of Lord Nottingham, the arms of equity were very short against the prerogative. The subtle distinction between which had been formerly attended the notion of privity of estate were also gradually discarded. Thus it was laid down by Lord Hale that tenant and dower should be bound by a trust as claiming in the per by the assignment of the heir. And so it was afterwards determined by Lord Nottingham, and when an old case to the contrary was cited by Lord Jeffreys, it was unanimously declared both by the bench and the bar to be against equity and the constant practice of the court. A tenant by statute merchant was held to be bound upon the same principle, for he took, it was said, by the act of party and the remedy which the law gave thereupon. But as to the tenant by courtesy, Lord Hale gave his opinion that one in the post should not be liable to the trust without express mention made by the party who created it, and therefore tenant by the courtesy should not be bound, but his lordship's authority on this point was subsequently overruled, and courtesy as well as dower was made to follow the general principle. Now, next section, as regards to the City Key Trust. With respect to the City Key Trust, or the person entitled to the subpoena, the narrow doctrine contained under the technical expression of privity began equally to be waived, or rather to be applied to considerable latitude of construction. The equitable interest, said Justice Roll, is not a thing in action, but an inheritance or chattel, as the case may fall out. And when once the trust, instead of passing as a truce in action, came to be treated as the footing of the actual estate, it soon drew to it all the rights and incidents to the accompanying property at law. Thus, the equity of the City Key Trust, though a bare contingency or possibility, was admitted to be assignable. In Whittingham's case, that a husband who survived his wife could not, for want of privity, claim her equitable chattel was declared by the courts to be no longer an authority. So the judgment creditor, it was held by Lord Nottingham, might prosecute an equitable fairy facius, and though the Lord Keeper Bridgeman refused to allow the equitable illegit, it was probable that had the question arisen before Lord Nottingham, his lordship, in this case, as in other cases, have acted on a more liberal principle. At all events, the creditor's right to relief in this respect has since been established by the current of modern authority. Again, a trust was decided by Lord Nottingham to be assets in the hand of the heir, and though Lord Guilford afterwards held the other way, yet Lord Nottingham's view of the subject appears to have been eventually established. Courtesy was also permitted of the trust estate, though the widow of the City Key Trust could never make her good title to dower, not, said Lord Mansfield, on reason or principle, but because wrong determinations had misled in too many instances to be then set right, or rather, in Lord Redesdale's thought, because the admission of the dower had occasioned great inconvenience to purchasers, a mischief that the case of courtesy was not to be equally apprehended. Now Lord Mansfield's doctrine, the principles governing trust at the present day. Lord Mansfield was for carrying the analogy of trust to legal estates beyond the legitimate boundaries. Quote, a use or trust, he said, was hitherto understood to be merely as an agreement by which the trustee and all claiming from him in privity were personally liable to the city key to use, and all claiming under him in like privity, nobody in the post was entitled under or bound by the agreement. But now the trust in this court is the same as the land, and the trustee is considered merely as an instrument of conveyance. And in the application of the principle, his lordship argued that the estate of the City Key Trust was subject to escheat, and that on failure of heirs of the trustee, the lord who took by escheat was bound by the trust. But to these propositions, the courts of equity have never yet assented. The limit to which the analogy of trust to legal estates ought properly be allowed was well enunciated by Lord Nottingham in the case of Burgess versus Wheat. It is true, he said, this court is considered trust as between trustee, City Key Trust, and those claiming under them as imitating the possession, but it would be a bold stride and, in my opinion, a dangerous conclusion to say, therefore, this court is considered the creation and instrument of the trust as a mere nullity, and the estate in all respects the same as if it still continued in the season of the creator of the trust or the person entitled to it. For in my part, I know instance where a court had permitted the creation of the trust to affect the right of a third person. That is, to illustrate the principles by instance, a tenant by the courtesy or in dower by illegit as claiming through the City Key Trust or trustee, those in the post is bound by and may take advantage of the trust, but according to the doctrine had laid down by Lord Nottingham, the lord who comes in by escheat is not in any sense a privity to the trust, and therefore can neither reap a benefit from it on failure of heirs of the City Key Trust, nor is bound by equity on failure of heirs of the trustee. Page 13, Part 1. Definition, classification, and creation of trusts. Chapter 1, Definition of a trust. Definition of a trust. As the doctrines of trust are equally applicable to real and personal estate, and the principles that govern the one will be bound by mutandis to govern the other, we cannot better describe the nature of a trust generally than by adopting Lord Cook's definition of a use, and the term by which before the statutes of uses, a trust, of the lands was designated. A trust, in the words applied to the use, may be said to be, quote, a confidence reposed in some other, not issuing out of the land, but as a thing collateral, annexed in privity to the estate of the land, and to the person touching the land, for which City Key use has no remedy but by subpoena in chancery. A, confidence. Next section. It is a confidence, not necessarily confidence expressly, reposed by one party and another, for it may be raised by implication of law that the trustee of the estate need not be actually capable of confidence, for the capacity itself may be supplied by legal fiction, as where the administration of the trust is committed to a body corporate, but a trust is a confidence as distinguished from just in re and just ad rem, for it is neither a legal property nor a legal right to property, to reposed in some other. It is a confidence, quote, reposed in some other, not in some other that the author of the trust for a person may convert himself into a trustee, but in some other that the city key trust, for a man cannot sue a subpoena against himself. He cannot be said to hold upon trust for himself. If the legal and equitable interest happen to meet in the same person, the equitable is forever absorbed in the legal. Thus, if A be seized of the legal inheritance ex parte paterna and the equitable's ex parte materna, upon the death of A, the heir of the maternal line has no equity against the heir of the paternal. And the same rule prevails to leaseholds for lives, and if the legal estate and the freehold lease be vested in the husband and his heirs in trust for the wife and her heirs, the child, who is the heir of both and takes the legal estate ex parte paterna and the equitable estate ex parte materna, will, by the merger of the equitable in the legal, become seized both at law and at equity, ex parte paterna, and the subsequent devolution will be regarded accordingly. How far the equitable mergers in the legal estate, next section. But this rule holds only where the legal and equitable states are comprehensive and commensurate, for if a person was seized of the legal estate in fee and have only a partial equitable interest, to merge one in the other might occasion an injurious disturbance of rights. Thus, before the Fines and Recoveries Act, if lands had been conveyed into and to use of A and his heirs in trust for B, entail with remainder in trust for A in fee, had the equitable remainder limited to A been converted into a legal estate, it would not have been barred by B's equitable recovery. In what sense mortgagee in fee is trustee for himself and his executors? In the case of the mortgagee in the fee, it has been said that a man and his heirs are trustees for himself and his executors, but the meaning was that until a release or a foreclosure of the equity of redemption, the interest of the mortgagee was the nature of personality and passed on his death to the personal representative. The heir, therefore, took the estate. Upon the trust for the executor, a release or foreclosure, unless it happened in the lifetime of the mortgagee, comes too late after his decease to alter the character of the property, for as the tree falls, so it must lie. Page 16, next section, trust not issuing out of the land, but collateral to it. A trust is not issuing out of the land, but as a thing collateral to it. A legal charge as a rent issues directly out of the land itself, and therefore binds every person, whether in the per or post, whether a purchaser for valuable consideration or volunteer, whether with notice or without notice. But a trust is not part of the land, but an incident made to accompany it, and that not inseparably, but during the continuance only of certain indispensable juncts. For number 4, annexed in privity to the estate. A trust is annexed in privity to the state, that is, must stand or fall with the person by whom the trust is created, as if the trustee be deceased and tortuous fee is adverse to the impressed with the trust. Therefore, the equitable owner, until the fusion of law and equity, could not have himself sued the deceiser, but must have brought an action against him at law in the name of the trustee. Next section, extent of the term privity to the estate. During the system of uses and also while trusts were in their infancy, the notion of privity of estate was not extended to tenant by the courtesy or in dower or by illegit or in fact to any person claiming by operation of law, though through the trustee, but in this respect the landmarks have been created forward. And at the present day, a trust follows the estate into the hands of everyone claiming under the trustee, whether in per or post. It was the opinion of Sir T. Clarke and Lord Nottingham that the Lord taking by escheat as claiming by title paramount and not either in the per or the post was not affected by any privity and therefore could not be compelled to execute the trust. But this question was never actually decided and has in great measure become immaterial. Now, trust annexed in privity to the person. a trust is annexed in privity to the person. To entitle the City Key Trust to relief and equity, it is not only necessary that he should prove the creation of the trust and the continuance of the estate supporting it, but should also establish that the assigned is not personally privy to the equity and therefore amenable to the subpoena. If it can be shown that the assigned had actual notice, then whether he had paid valuable consideration or not, he is plainly privy to the trust and bound to give it effect. But if actual notice cannot be proved, then if he be a volunteer, the court will not affect him with notice by presumption of law. The court will still affect him with notice by presumption of law. But if he be a purchaser for value, the court must believe until proved to the contrary that having paid for the estate, he was ignorant at the time he purchased of another's equitable title. A purchaser for valuable consideration without notice, therefore, is the only assigned against whom privity annexed to the person cannot at the present day be charged. 6. No remedy of the City Key Trust but in Chancery. The City Key Trust, quote, has no remedy but by subpoena in Chancery. See number 1. And by Chancery must be understood not exclusively the court of the Lord Chancellor, but any court invested with equitable jurisdiction as opposed to common law courts and spiritual courts, neither of which, until the fusion of law and equity, had any cognizance of matters of a trust. A common law court could never, from the defective nature of its proceedings, have specifically enforced a trust, but at some time it affected to punish the trustee in damages for breach of an implied contract. An exercise of authority, however, clearly extra-provincial and afterwards abandoned, had a spiritual court attempted to meddle with a trust, the court of the Queen's Bench might have been moved to issue a prohibition. Next, section 36 and 37, Queen Victoria, section 66. By 36 and 37, Victoria, section 66, and 37 and 38, Victoria, section 83, it was enacted that as from November 1st, 1875 inclusive, there should be one Supreme Court jurisdiction consisting of Her Majesty's High Courts of Justice and Her Majesty's Courts of Appeal, and the High Court of Justice was made to comprise 5 divisions: the Chancery Division, the Queen's Bench Division, the Common Plea Division, and the Executure Division, and the Probate, Divorce, and Admiralty Divisions. But by order of the Council dated 16th of December, 1880, under Section 32 of the first mentioned Act, the Common Pleas Division and the Executure Division have been abolished. Equitable estates and rights are now to be noticed and enacted upon in all courts, and where there is any conflict between the rules of equity and the rules of common law, the rules of equity are to prevail. See sections 24 and 25 of the first mentioned Act. Subject to any rules to be made in pursuance of the new enactments, all causes and matters pretending in the Court of Chancery at the commencement of the Act of 36 and 37 Victoria are transferred to the Chancery Division of the High Court of Justice, and the subject, as aforesaid, all causes and matters for the execution of trust, charitable or private, are to be assigned to the same division, and for that purpose, every document by which the cause or matter is commenced is to be marked for that division and with the name of the judge to whom the cause or matter is to be assigned. See sections 33 and 34. Chapter 2, Classifications of Trusts. Number 1, trust simple or special. The first and natural division of trust is into simple and special. Simple trust now. The simple trust is where property is vested into one person upon trust for another, and the nature of the trust, not being prescribed by the settlor, is left to the construction of law. In this case, the City Key Trust has justus habendi, or the right to be put into actual possession of the property, and justus dispondi, or the right to call upon the trustee to execute conveyances of the legal estate as the City Key Trust directs. Now, special trust. The special trust is where the machinery of the trustee is introduced for the execution of some purpose particularly pointed out, and the trustee is not, as before, a mere passive depositary of the estate, but is called upon to exert himself actively in the execution of the settler's intention, as where a conveyance is to trustees upon trust to sell for payment of debts. Number 2, special trust, either instrumental or discretionary. Discretionary. Special trusts have again been subdivided into ministerial or instrumental and discretionary. The former, as a matter no further exercise of reason or understanding that every intelligent agent must necessarily employ. The latter, such as cannot be duly administered without the application of certain degree of prudence and judgment. A trust to convey an estate must be regarded as ministerial, for provided the estate be vested in the city key trust, it is perfectly immaterial by what manner of a person and conveyance is executed. And now trust to sell held by Mr. Fernie to be instrumental. A trust for sale was considered by Mr. Fernie as also ministerial. Quote, for the price, he said, is not arbitrary or at the trustee's discretion, but to the best that can be gotten for the estate, which is in fact to be ascertained independently of any discretion in the trustee. But there is much room for judgment in the time and the mode of proceeding to a sale, and the precautions that are to be taken will have a material influence upon the price, and Mr. Fernie's opinion cannot at the present day be maintained. And now next section, examples of discretionary trusts. A fund vested in a trustee upon trust to distribute among such charitable objects as the trustee shall think fit, or an invowson conveyed to them upon trust to elect the present proper preacher, is clearly a discretionary trust. For the selection of the most deserving objects in the first instance and the choice of the best candidate in the second is a matter calling for serious deliberations, and not to be determined upon without due regards to the merits of the candidates and all the particular circumstances of the case. Number 3, mixture of trust and power. There is frequently mention made in the books of a mixture of trust and power, by which it is meant a trust of which the outline only is sketched by the settler, while the details are to be filled up by the good sense of the trustees. The exercise of such a power is imperative, while the mode of the execution is a matter of judgment and discretionary. And now distinguished from trust with power annexed, a mixture of trust and power is not to be confounded with a common trust to which a power is annexed. For in the former case, just as a trust to distribute at the discretion of the trustees, they are bound to all events to distribute, and the manner is only left open. But in the latter case, the trust itself is complete, and the power being but an accessory may be exercised or not as the trustee may deem expedient, as where the lands are limited to trustees with the authority to grant leases, or stock as transferred to trustees with a power of varying the securities. For in such cases the power forms no integral part of the trust, but is merely collateral and subsidiary, and the execution of it, in the absence of fraud, cannot be compelled by application to the court. Number 4, trust lawful and unlawful. Again, trust may be divided with reference to the object in view into lawful and unlawful. The former, which are directed to some honest purpose, such as to pay debts, etc., which are called by Lord Bacon intents or confidences, and will be administered by the court. The latter are trusts created for the attainment of some end contravening the policy of the law, and therefore not to be sanctioned in a form professing not only justice but equity, as a trust to defraud creditors or to defend a statute. Such are designated by Lord Bacon as frauds, covens, and collusions. Number 5, trust public and private. Another division of trust is into public and private. By public must be understood as they are constituted for the benefit either of the public at large or of some considerable portion of it, answering the particular description. To this case belongs all trusts for charitable purposes, and indeed public trust and charitable trust may be considered in general as synonymous expressions. In private trusts, the beneficial interest is vested absolutely in one or more individuals who are, or within a certain time may be definitely ascertained, and to whom therefore collectively, unless some legal disability, it is, or within the allowable limit, will be competent to control, modify, or determine the trust. The duration of trust of this kind cannot be extended to, or extended by the will of the settlor beyond the bounds of legal limitations. There is a life or lives in being with engrafted of 21 years. A public or charitable trust, on the other hand, has for its objects the member of the uncertain or fluctuating body, and the trust itself is of a permanent and indefinite character and is not confined within the limits prescribed to the settlement upon a private trust. So I think we'll stop there. We'll pick up next time on Chapter 3. And now we'll open up for questions on a baffling topic.
Folks,
Go ahead,
if you got
Matt.
a question, yeah. Thanks, Christian. That was a good introduction to this new book. If you got questions, folks, hit star 8 on your phone. And I'll go ahead and unmute you. West, North Carolina. Can you hear us? You've been unmuted.
Hello.
Yep, go ahead with the question.
How you doing, Christian? Good evening.
Good. How about you?
Doing all right. My first question is for you. Got a situation where I have a car loan, and I was actually a co-buyer as far as being, it was my girlfriend and I, and as far as being the co-signer, but she's really not into this type of stuff here, so it's basically me. I have a power of attorney over the whole situation, and I wanted to know, would that affect me doing my process as far as in expressing the trust is concerned? Would I be able to go in and deal with the entire situation myself?
Power of attorney would probably give you agency standing. What was the agreement as to the limitation of the power of attorney?
Excuse me?
What would be the limitation on the authority to act on behalf of?
Oh, there is no limitation at all. I actually have it's a generic general power of attorney, and we check the little boxes, and I actually have claims and litigations as part of the powers that I would have, but it's basically like unlimited.
Well, unlimited power, I suppose that's all you need to effectuate what you needed for.
Okay, beautiful. Then my next question would be, would I be able to get a remedy as far as my situation is concerned without having changed my master file, I guess being by 1040 or SS5?
Well, that's a question
Or do I
can't
have
really
to
answer because, I would say that it would be a higher degree a higher degree of success or remedy if you didn't correct the master file, even though correcting it probably even get you a higher degree.
Okay, that sounds good to me. As far as the DIB hearing is concerned, Treasury Direct 25-06, I actually found it earlier today online. Is all of the information there for me to actually call a DIB hearing correctly without being denied, or is there further research that I would have to do?
Yeah, we're checking into that further. That was just a DIB hearing that has been set up, and we found out that we might have to go through maybe some specific processes. We're trying to discover if there is something like that.
Okay, cool. That sounds good. I guess the next thing would be, as far as what it is that I'm doing, the UCC1, UCC3, I'm moving the titles, I'm going to claim the title. Do I want to wait for them to, as you would call it, arrest me, or do I go in as plaintiff or third-party plaintiff? Because I think I heard you mention at one time that it would actually put you in a better position if you were to go in as a third-party plaintiff.
Well, if you had knowledge that they were going to breach the trust, you could make an action against them and come arrest or foreclose upon them first and prevent them from breaching the trust.
Okay, well, what the actual situation is, I actually haven't made a payment. I've sent in, before I found out about you and the whole NTT movement that's going on, I was really into the debtor-creditor, as is everybody else, and I did the whole notary presentment, and I actually have my certificate of dishonor, and I was about to get into, the commercial liens and true bills and things of that nature, but then I stumbled upon the NTT, and it just makes so much more sense to me to do it this way. So I guess, how would I actually utilize my certificate of dishonor? I know you said to use it as trust res property, correct?
You could, but I would use the certificate of dishonor as a colorable way to, jam up the courts, give you some time to merge the titles.
Okay.
Have you looked under Black's Law, 8th edition, the definition of merger?
No, I haven't, but I can actually pull it up real quick because it's actually...
You might want to look up the definition and really study it. It says that in the quote, it says where two parties have made a simple contract for any purpose and afterwards have entered into an identical engagement by deed, the simple contract is merged in the deed and becomes extinct. This extinction of the lesser in the higher security, like the extinction of the lesser in the greater interest, is called merger. So we have this simple contract, this simple debtor-creditor relationship contract that is merged in the higher security, which is the trust, and when you do that, the debt becomes extinct. That's the merging of titles.
Yes. And I would be merging these titles by way of transfer on a UCC3, right?
Well, no, you're not merging them by way of the UCC3. The UCC3 is just a notice that you have merged it.
Oh, okay. So I was misinformed when it came to that right there.
Yeah, because when the present transfer of trust res and it gets it in the hands of the trustee, at that moment, when he has trust res in his hands, that is when the trust is formed. Now, I'm going to say 3 days later come up with the notices of the fact that that's already taken place. But that's just the record of a past transfer. That's just a notice of a past transfer.
Yeah, and I'm glad you said that because I actually wanted to ask you about that also. This actual trust, the colorable contract that I signed was about 3 years ago now. So how would I go in now and re-express a present, I should say, transfer of trust res property?
Well, first of all, I want to get them in a dishonor where I asked them, say, for a debt validation if they never answered. Then I would certify that by the notary, because I would do it all through a notary process. And then use that dishonor generated by the notary to give me a means for revoking the past contract, the debtor-creditor contract. So I'd be doing this on the colorable side, something that they could see that would be revoking the contract, knocking out the contract, because they never validated the debt. Then I could also get a certificate to come in as with, say, unclean hands and come into a court of equity and have equity actually kick out the thing on that side. And then I would come in simultaneously with the merger of the titles on the private side of the court and extinguish the debt by that means. So now they got a colorable way out looking at it on their side, because now they don't have to stand on, and I've extinguished it anyway, merged it on the private.
Okay, so my certificate of dishonor, I would use that as some sort of a cause of action to jam them up in courts on the public side and then come in on the private side, merging the titles to extinguish the debt.
Yes, simultaneously.
Okay, so on the public side, being that I do know that the public side has an equitable feel to it, but it's still statutory, would the same rules apply as far as how I go? I'm still going in, expressing the trust and expressing myself as a beneficiary, correct?
Yes, a beneficiary on the private side, yeah.
Beneficiary on the private side. So, okay, on the public side, then how would that work?
You might want to be trustee.
I might want to be trustee on the public side. Okay, so listening to the tapes that of the actual audio files, I remember hearing you say that if I'm going to go in as trustee, I'm going to acknowledge the debt, which is going to take care of the controversy, and then is that the time that I would want to go into chambers and give them the reason why as trustee under a discretionary trust of why I didn't make the payment?
That's one way of doing it, or you could actually issue the payment and tell them it's been paid because I've merged the titles.
And all of this is still on the public side.
No, that would be on the private.
Merging the titles would not, definitely. Merging of the titles and speaking of that would be on the private side.
Right.
Okay, because I'm trying to get my bearings, and what you said to me.
I was required to make a payment, and they're saying I didn't make a payment. Now I got to come up with a record of payment. I've got a record of payment. It's merger, and it's my notices on the UCC3s that I noticed them that it's already been transferred prior to that.
Okay, so the bank has me misconstrued as the trustee right now. So I would send a presentment to the bank, and being that I am the grantor of it and I do have power of attorney over everything, I would send a presentment to the bank by way of notary presentment and re-express the roles, correct? Me as being the beneficiary and them as the trustees?
Well, something I was going over a little bit last night. Let's see if I can find it. We're talking about the beneficiary. Let's see if it's in this one. Let me see if I can remember it correctly. It's not really necessary for the trustee to let known who the beneficiary is. It's none of their business.
Okay.
So I don't need to express, as trustee, identify who the beneficiary is. Now, I could be the beneficiary on the private side, but I don't have to disclose that as trustee on the public side.
Ah, that was what was confusing me, that part right there. Okay. So on the public side, I'm acknowledging the debt as trustee, correct?
If you understand it that way and can play it that way, that could be one way that I would play it. Because now I have the ability to make the payment, and I did make the payment. So under a court of equity, they're going to assume that the trustee is guilty unless he's got a receipt of payment. Well, I happen to have a receipt of payment. It's the merging of the titles that paid it, that extinguished the debt. It merged the lower contract, the debtor-creditor contract, into the trust and extinguished the lower contract and the higher interest.
Wow. So am I merging these titles within myself or within the financial institution? Because if I'm trustee, then I would have legal title, and if they're beneficiary, then they would have equitable title. So would I be transferring the legal title to them?
No, you'd be transferring the trustee is the head of the trust, and it's affecting and has an active party in the trust. So the merging of the titles would be, say, in the trustee.
Okay, so how do if they have the beneficial title, I can move the title from them to myself?
Yeah, you could in a roundabout way. I would have to get them from that dishonor. Now they're constrained their beneficiaries on the public side, so you probably have to leave that the way it is. But yeah, you'd have to get them in a dishonor, which you already have if you ran it on that debt validation.
Yes.
That you could transfer their beneficial interest. I have to merge their beneficial interest. I just need to take their debt title they're trying to make me pay and merge that into the trust. And that would extinguish the debt.
Okay, now that's the part that's confusing me when you're saying take the debt title. I know there's a debt title and there's an asset title from the chart that you have with the ledger chart, the upside down T, and they have the debt title, correct?
That was the bill that they sent you, the offer for the free offer for the obligation to pay. That was the bill that they sent you. The bill that they said was due. That's the debt title.
Okay, now the bill itself is only an actual car payment. I want to take care of the whole entire thing.
Oh, sure, you could do that. Yeah, take the whole obligation, pay it all off.
That's what I want to do. So so that means then I can't use the actual coupon slip that comes in. How would I go about taking care of the entire debt? Period.
Merge that with the asset title and give them notice that it's been extinguished.
Merge that with the asset title. I have the asset title. They have the debt title.
Yeah, but when you get a hold of the debt title, you're going to put your asset title on that debt title. And what you've done is you put them both together, and then you return it back to them as the receipt that's been extinguished.
I'm trying to get a grasp on that right there, because from listening, I had a total different way that I thought that I was going to go about it until talking to you tonight. I was under the impression that I would need it to express myself as a beneficiary on the SS5 and hopefully the 1040. Then go in and appoint them as the trustees. Equity would automatically look at them as the trustees, which would make them guilty. I would go into chambers and have an in camera and have them apply the payment, which was through my original promissory note that I signed.
Yes, you could do it that way also.
That's the model that I've been going after for like the last month and a half or so, 2 months since I've been going through all of these files. So I think I would rather do it that way.
Okay. If you understand it better that way, then you might want to check out this other way of thinking also.
No, definitely. You're absolutely right. Definitely. But this other way of thinking, I'm still having an issue grasping that of the debt title and the asset title, the role that I play, and what is it that I hold as the trustee if I'm going to be the trustee on the public side.
Yeah, because this way I wouldn't have to be so secretive and make sure everything is kept on the private side so much, because I could come right out and say, well, okay, I am the trustee on this. As trustee, I get the right to make a payment. And so where's your payment? Well, okay, I've already merged and extinguished the debt, and here's the receipt of the payment.
Okay, now that part right there is what I need more clarification with. Okay, I merged both of them, and here's the receipt. Where does the merger come in from, and what would be the actual receipt?
The same way that you merge titles on your first model that you understand. The moving titles platform, which would be the UCC1 in the county and the UCC3 in the county. So when they send the offer, I would name the offer on the UCC1. I would put the information on that offer that turned it into the debt title, and then send it to them with notary presentment, and then create the threes, UCC3 in the county that I've done the transaction. And that merged the titles then. When I return it back, I put my asset on it, on their debt title.
Okay, so the title, so both of them have to be of equal value. Now, like I said, I would want to be taking care of the whole entire thing. So using the actual coupon slips, that's not an option. So how do I know I would be taking care of the entire debt itself? Like, what is there specific verbiage that I would have to use on the UCC1 and the UCC3?
Well, did they send you a total bill?
No, they haven't sent me a total bill. They're actually still sending me car payments.
Ask them for a
sorry?
what's the cost of the total payoff? And then
the cost of the total payoff would be, I think it's about $27,000.
Well, if you're not quite
I know the total payoff much.
And ask them to send you the overage back.
I'm sorry, say that again?
I say if you're not quite sure what it is, you know about what it is, send them more than what it is to cover it, and tell them, well, whatever is excess, send it back.
Send it back, okay. All right. And this is all being done with the UCC1 and the UCC3. I can actually put those numerals in there. I guess it would be in... Huh?
As a notice.
As a notice, okay. As a notice. Now, on the notice, which would be the UCC1 and the UCC3, like you said, it's just a notice. The numerals, would actually be putting those numerals on there, or would that be a separate document and say like an affidavit form and make reference of what I have on my affidavit?
Well, as I said, I would do a notary that presents or represents that back to them, that I have combined the two titles. I put my asset title on top of their debt title, so to speak, and sent it back to them by notary. And when they got it, that's when the trust forms, because that was a special deposit for formation of the trust.
Okay.
And that now is
all right.
The actual formation of the trust at that time, and I'm going to put in the UCC3s in the county. That's just notifying the public that that's what's been done. Now I got two public witnesses that I've actually merged the titles and done the extinguishment.
Okay, so before the actual merging of the titles or making public notice of the merger of the two titles, how would that take place prior to that? Because you're saying to put my asset title on top of their debt title. Where would that, like, I'm still trying to get a handle on where would that take place? Like, how would that?
Well, the debt was that they sent you.
Yes.
And now I'm going to put my asset, which is my signature, on that.
That's what I needed to hear. Okay. All right.
Because my signature is what pays it, really.
Yes. That was the part that was tripping me up. That's what I needed to hear. So it's my actual signature that they would be able to convert that into whatever funds, whatever amount that they need, take that and put that on top of the debt title and distinguish it like so.
Right. In the front, I would write at a 45-degree angle, write my name across it, and put a date on it, and see reverse side.
See reverse side. Okay.
And on the reverse side, there's where I would endorse it with a special deposit endorsement.
Say that again, I'm sorry?
On the back side, I would endorse it with a special endorsement, a special deposit endorsement.
So I would actually use the word special deposit on the back of it with a qualified signature.
Yeah, if I didn't put special deposit on the front, I want to put it on the back.
Okay, so now this document that I'm actually doing this writing on, what would it be? Like, does it have to be something that comes from them with a letterhead from them, or can I create it myself and say, this is how much you say I owe? If that's the case,
I like to see a letter come from them, because that's what they sent me. That's their debt title they're claiming.
Okay, so that means, because I haven't been in contact with them. I mean, they call every day and send letters every now and again. So I basically will have to contact them again and ask for a payoff statement?
Yeah.
That's what I needed to hear also. Okay.
That would be their debt title.
That would be the debt title. I need a total payoff statement. I could come up with whatever reason to tell them, just send me how much I need to pay you to take care of everything. And once I get that from them, that would be the debt title. I make an endorsement out of that and turn that into, okay, I got you now. I got you. Okay. The
You want to
workshop.
sign restrictively on these things. You want to put the offices that you're performing in. If you're grantor in the front, then you want to be on the back, endorser as, say, trustee.
Trustee, yeah, because I'm making the payment, so I would have to be the trustee.
Yeah, so you're doing like an acceptance on the front, but although it's not acceptance under trust. They're going to put by grantor, say, on the front. And then flip it over, and you're going to make a payment. Then you're going to do an endorsement, and it's going to be by trustee.
Yes. Okay.
And
is there any
special endorsement comes in without recourse and say for special deposit to, and then leave it in blank. Now it's a bearer form. And you put next line by trustee, your signature, and then the line under that for, and then the straw man all caps name and social security number without the dashes.
Okay, so then I would have to go back early into your NTT Moving Titles platform, because that's when you were basically on debtor creditor but had a trust twist to it also. So it's like not A for V, but dealing with it in trust terminology, correct?
Right.
All right, so now you gave me what I needed basically for the back. Now on the front, is there anything special that has to go at the 45-degree angle?
Other than by grantor, my signature, and a date, that would be the minimal I'd put on there, and see reverse side.
Oh, all right. Okay. Great. That sounds great.
I could modify it from that if you understood. You could make that whole front like in a check form and put all the information that a check has on it. You could go one step farther and you can make it like a check on the front.
Okay.
But the bare minimum that you need on the front side is your by grantor and a date and say see reverse side.
Okay, good. So my best bet is to actually go in as the trustee then, but keeping them from breaching the trust first, because this has been going on for about 6 months now since I've actually made a payment since I was doing.
Yeah, actually they're looking at you as you've breached the trust, and since your IMF form has got you down, you've self-assessed yourself as being trustee, then they're probably right.
Yeah. So I might as well roll with those same punches then, just learn how to use them.
So now the Court of Equity is going to assume that the trustee is guilty and hasn't made a payment. But trouble is, you got the records to prove that you have made a payment.
Yes. Okay, that sounds great. All right. Now, registered mail, when it comes to creating a title, how do I can use the actual registered mail number as a title if I had to create one, right?
Right.
How do I keep that number? Can I just stick it on an envelope and just mail it to myself?
Yes, and cancel, pay the fee. Yeah, have it canceled. Send it yourself.
Send it to myself, pay the fee, have it canceled. Now, am I paying the whole registered mail fee, which is about $22 here in North Carolina, or just the cost of a stamp?
What is the stamp? About $8.50, $9.50, something like that?
No, like 45 cents, if I'm not mistaken. I don't know.
No, the registered mail stamp, I think it was like $8.50 for the.
Oh yeah. Oh no, the registered mail stamp. Well, they're actually the actual stickers themselves with the numbers. They're free, but when it comes to actually using the service, the last time I used it to send out a presentment, I think I paid like $20-something. It was like $17 or $18.
Maybe it went up. Last time I used it was like $8.50.
Yeah, well, it definitely went up because when I was sending out my notary presentments under debtor creditor, I used it a couple of times.
Okay, so apparently it must have gone up since the last I've used it. So.
All right. Okay. All right. North Carolina is both a judicial and non-judicial state. They use more non-judicial activity here, so does that change up in any way my process or how I would go at them under equity?
No, because I'm going to have to go in court to get equity to, the only way I'm going to find equity is in court.
Yes. Okay. All right, so my best bet is to go at them first, bring them in for what would be my cause of action, because they would try to bring me in as for under breach of trust, what would be mine?
Cause of action would be it's paid.
Okay, it's paid. Okay, cool. I guess my last question would be the workshops. I kind of don't know when the workshop. Have you had any workshops already?
No, we've just been laying foundation. We haven't
laying
come.
The foundation.
Well, believe me, everybody that sent me an email will get a notice when we do the workshop.
Okay, all right. So you don't have no workshop and there's no website up right now, correct?
Correct, right.
Okay, so we're just all audio files, talk shoe and things of that nature. Okay, that sounds good to me. I think you answered all of my questions that I have for tonight. I really appreciate your help. Keep up with the good work, and I'll be following right along the whole way.
All right, thanks. Appreciate it.
How do I mute out?
*6.
*6. Thank you.
Great questions. Thank you for calling in tonight. Next caller, Mike. You've been unmuted. Go ahead.
Yes, this is Mike. Hi,
hey, Mike.
Hi.
Thanks for the call.
Yes. Okay. Most likely, I'm the only man in the world which are confused by UCC3 by now. My first question is about that. Are we going to use UCC3 to merge the titles?
No, UCC3 does not merge the titles.
Or to make a notice of merger titles?
Yeah, it's a notice that a merger has taken place and announces it to the public. But it doesn't disclose any information other than it's just a public notice, and all the information that it has been merged is really not on that.
I understand this. Okay, it's a notice. I'm still getting used to, to use right phrasing. So it's a notice of merging.
Notice that you've merged the titles, and you're telling the public you need to look and check it out further. But it's not the actual document that merged the titles.
Right. I understand this. It does remind me what Greg was teaching us almost a year ago when he was he used a little bit different names for the asset side and debt side to match both sides to zero the account. But obviously he was doing this a little bit more on debtor, creditor debtor side. But you also told me, I believe that's how I understood it, that UCC3 is also the notice of the transfer of the trust res. Am I right about that? Because that's confusing me.
Yes, that's right. That's correct.
Okay, so it looks to me...
Notice that doesn't mean that it actually was the mechanism.
Yes. I have to deliver trust res and then make a notice of it on UCC3.
Yeah, the notice is just that you're creating a public record that can be seen in the public, and the public has been noticed that has happened, and now you got your evidence that you can take in, and if you ever needed it.
Okay, so the way I see it, I would use UCC1 to notice that there is a trust, and then eventually.
You're noticing that your UCC1 is that you're claiming the res or the asset as being yours, and now if it's yours, I can do something with it. I can move it.
Okay, so let's say I move it to a trustee and make a note of it, transfer it to the trustee, make a public notice of it on UCC3, but then eventually I can merge the titles and then use UCC3 to make a public notice of it. So it looks to me like we're using UCC1 and then UCC3 twice if we decide to merge the titles. Am I right?
You can use it twice, yes. The first time would be to form the trust, and the second one would be, say, to merge the debt and with the asset.
Okay, that's great. That's cleared up for me.
And you can do it all simultaneously in one, though, too.
Say again, please, because I interrupted you.
can also do that all in one also.
Okay. And then would I use just one UCC3?
Well, there may be instances when you could.
Okay. But
then there are instances when you're going to have to form the trust first and then maybe do something with it later.
So let's discuss this quickly about the trust I'm having in mind. Last year I sent 1040 to IRS. Okay, and actually when I think about it, the way I sent it, it was with OID of my checks, and at that time I've heard of people who are just filing current year of with OIDs electronically, and they received the checks. Obviously they went under the radar, and then they received the checks. But I didn't want to send to IRS that way because my thinking was that if the truth is that OID should work and it's proper way to get the created credit, let's put it this way, or rather created funds out of my credit, and is the proper way to return it to me, I want to IRS to look at this and confirm it to me. So when I think about it, I created form of trust at that time. I granted them some form of trustship that for benefit of my strawman, let's put it this way. And 1040 from 1040 could be viewed by me right now as a declaration of trust, and the fact that I the transfer that document to them is another form of creating the trust. Am I kind of right in my thinking about the trust issue?
Yes, you could. But how did you sign the documents?
I did not sign the any other way than just my name at that time.
No qualifiers and no positions of an office of a trust or anything like that.
No, I didn't even knew you exist, Christian, at that time. Unfortunately,
you didn't express a trust. That doesn't mean that a trust is not in existence. You just have the records and made it so, and you haven't notified them.
I understand this. And that's what I'm thinking, because it came back to me, and obviously they didn't send me a check, as you might suspect. They sent me a notice of deficiency and a new assessment, which really I cannot ignore, and I have to fight it. And first thing, I sent some administrative letter to them. I'm going to give them opportunity to cure and default them, which, according to you, gives me a judgment, administrative judgment, to claim they are dealing with unclean hands. They are not dealing with clean hands. But now I have to take them to tax court. Okay. I don't know. The way I see it, I think tax court is kind of in-house deal of IRS. Do you know anything about it, by the chance?
About the tax court?
Yeah.
Well, if it's a regular court of equity, you should be able to get a remedy in there.
Yeah. Okay. Now, I kind of made my mind that I will try to prove the trust there if I will have enough time. Okay. And since I will be the petitioner, would you, in my position, treat this petition as a trust, which eventually includes my 1040 like a sub-trust or just a trust as altogether as a trust rest. And the court proceeding would be trust itself. That's how would you approach it in that position, that situation? Hello?
Did we lose
Hello?
Christian? Are you there, Christian?
I would, I'm all about trust. That's the only way I'm going to treat it. So I'm going to treat the offer that they sent me for a deficiency or a bill. I'm going to turn that into a special deposit and merge it on itself and extinguish that as a debt.
Okay. But my thinking also is that I just don't want to get this out of my, I just don't want to release myself of this problem. But if I really believe that they should return to me my credit, which I trust that they will, I would like to see, fighting for.
Mike, see that they never will return your credit because under the debtor-creditor realm, you made a general deposit, which puts you in the debtor-creditor situation. They don't have to return your credit because under that realm, it's not your credit.
Okay.
The only way it's going to be your credit is if you made a special deposit, which is a trust deposit. Now you can order it back because it is yours. I think that's the main flaw of the whole debtor-creditor realm, why we really haven't had any success of remedy. It just doesn't work under debtor-creditor, period. No way. If you start studying trust, it's going to become apparent your remedy is not under debtor-creditor at law. It's under equity and trust. That's it.
Okay,
anybody that's studied a little bit and has got some smarts in it and got some knowledge background under their belt is going to start seeing that.
Okay, so I should take this a notice of deficiency, an assessment letter, and treat this as a bill, accept this bill, return to
Not a
them.
bill, it's a bill under debtor-creditor. It's now a debt title, and I'm going to merge it with the asset title under trust and extinguish it.
Okay, so I use this as a debt title, and I hold in my possession, right? I just claim it's a debt title, and through notices, I will express that to the public. But I don't have to. I'm sorry.
As a special deposit under trust.
Right, as a special. Okay, and I keep it as a special deposit because it seems to me like special deposit I have to deposit to trustee, right?
Say that again, trustee. But
if this is special deposit, the word deposit means I have to deposit it. So in my mind, I have to return to them.
Yes, return it to them.
Okay, but I don't have. I believe you just discussed this with this gentleman how to do it. But could you repeat that? Just how I would do this. So I have to accept this. And
yes, the offer of the bill, which is the debt title. I'm going to receive that because they sent it to you.
Okay.
I'm going to put an asset title on it, which is nothing more than my signature. And I'm going to endorse it, turn it back to them. And when I put the asset along with their debt, they're together, aren't they? Or they're on the same document, really. And I return it back to them as a special deposit. And that's an application of the, they zero each other out then. Because the debt equals the asset. They're merged. They're zeroed.
I understand. It's kind of they informing me that there is a new accounting and there are two sides of the assets, and they just they're showing me just a debt title, but I know there is a asset title, and I can express this through my signature.
Yeah, there is a new accounting, all right, because you're taking out of the debtor-creditor accounting system under GAAP, and you're coming in back in under equity, and you're taking and putting it into a whole different realm. It is
Okay.
is no longer the same thing any longer. Definition of equitable asset. Equitable assets are assets which are chargeable with payment of debts in equity and do not fall under the description of legal assets. Those portions of property which by the ordinary rule of law are not from debts, they're exempt from debts, they're exempt from debts, but which the testator has voluntarily charged as assets, or which being non-existent at law have been created in equity, and they are so called because they can be reached only by the aid and instrumentality of a court of equity, and from that which governs the distribution of legal assets. So it's a whole different realm. It's an equitable asset that you're applying to that debt title, that debt asset. And it can only be gotten through equity. There's where our remedy is. Our remedy is not at law. Our remedy is in equity.
Yeah, you keep repeating this. Yeah, we have to learn more about it. But I'm coming back to the technically. So I have to just sign it on the front and endorse it on the back and return it to them. I would do this via register mail.
I'm giving them enough information on there that it looks like it's a negotiable instrument to them, but it's not. It's a special deposit because there's nothing on there I'm going to put on there as negotiable at all. In fact, I'm going to put non-negotiable on it, and that really means special deposit, which also means private. It's all private.
Okay, but I can also put special deposit wording and
yes, in fact, on the endorsement side, you put without recourse on the first line. On the second line, we used to have pay to, but I think it's better if we put on there special deposit to, and then leave it as blank. And then the next line, you put your by trustee, and then you endorse it. And then under that is the strawman cap's name plus the Social Security number, and that's the account that it gets paid, and it looks like that's what it's coming from then.
Okay. All right. Okay. But I would not do this before I prepare all the other documents. And I've heard you were talking about...
Which documents are you referring to?
I've heard about declaration of the grantor status. Should I have this in my possession as a documentation of the trust? Or
you could.
What about the indenture? Is this the same thing? I'm still learning. I'm sorry. I'm asking you this question, but I've heard so many times from you some wording, and I'm trying to put this together because
things happen here. One is, you're confusing with trying to get at the master trust, which would be correcting the master file, IMF, and claiming the whole straw man account, or that's one thing or one issue. And then, but you've got this bill, and I would treat this bill like separate all by itself, and that would be another sub-trust that I would be forming and closing it. And then from here on in, I would treat everything as trust. And then I could go back and claim the whole thing when we know more about what's going on.
My thinking is that what I have to really have in my possession, if it comes to the meeting with the judge,
you just need
in private.
That offer that they gave you, turn it into a special deposit, give it back to them, create the records that you formed a trust right then and there, get the evidence that you need, go into this DIB hearing that you made the payment, and just like the other fellow that was before you, that's the record that you made the payment, which was by merger of the titles, the extinguishment of the debt.
Okay. I think I exhausted all my questions for tonight.
The problem is into where there are many trusts that we're dealing with, and we think they're all the one, and they're not. There are probably thousands of trusts we're dealing with all the time, and we aren't even aware of it.
No, this is not my thinking. I know we're creating trust. I understand this. I'm not trying to confuse master trust. I'm trying to understand what I have to have in my possession, in my hands, and what I had to do to have all complete information for this specific trust, whichever it is. And in this case, it's this 1040 I have. Okay, I'm not trying to correct my master file right now, but I know that I have to have notices and witnesses of this trust, but these notices are noticing of some document put the notice of some documents, and I have to understand what documents I have to have in my possession to eventually, if it comes to it, I can prove this trust. I'm talking about
ones and the UCC 3s, along with the counties.
Okay, these are witnesses, right? Okay, but those witnesses, if I have to present to the judge, what else I have to have? Nothing else, no documents.
Okay, the administrative process that I use is send trust res to the trustee or whoever I sent it to.
Okay, so eventual documents showing the copy of the trust res. In this case,
it's just like if I give you my pen, I say I want my pen back. We just formed a trust. There was an oral trust. It was implied, but yet everything is there for the law to recognize it being a trust. There was no indenture, nothing in writing. In fact, nobody even knew there was a trust taking place. But
what about 1040? Is it if I have to have a copy of it as a trust res if I treat this as a trust res or part of the trust res?
Well, I would use the bill they're sending you as the debt.
Okay.
Not 1040.
Okay. So then I have it.
They're self-assessing you and changing your records around and saying, okay, you come up and they say, well, you owe so much amount of money, and then they send you a bill for that. They self-assessed you. That may be off the 1040, but I don't care what they throw at me. Just take whatever they throw at you. That is the free offer for the obligation to pay, but how are you going to pay? That's the big question. Are you going to pay with a special deposit, which is really merging the title with the asset, and that's the extinguishment of the debt, or are you going to make a general deposit, which is going to put you under debt or credit, and you're still going to owe?
Now I'm going to make this as a special deposit, Christian. And if I understand this correctly, the only documents which is eventually desirable for me to hold is the copy of this assessment. I send them back, and eventually, let's say, register mail documents that I did it alongside UCC1, UCC3s, and another witness, the county.
Yes, and then the notary doing the presentment of all the documents to them, so that's arm's length third-party witness that can certify that it was sent.
Okay, so I should send them under notary presentment. That's what you're saying.
Yes, or at least some kind of third-party witness.
Okay. I'm fortunate enough I do have
notary, because the notary, whatever he generates a certificate, that is outside the evidence rules. It's exception to the hearsay rule.
Okay, but I do have a notary, so it makes sense for me to use it, right? To use him.
I would.
Okay. Thank you very much, Christian. Thanks. Thanks a lot.
One word of caution to everyone. It's like when you don't have any more questions, or if you can answer your own questions, then I would say you're ready to try this. If you're still asking questions or you're unsure of something, it's better not to do it at all and just allow what happens, because maybe you might get yourself in worse trouble by not understanding it, doing it before your time.
Great advice. Thank you.
one word of caution on that.
Thank you.
That's not
Thanks,
just
Matt.
you, that's everybody.
Yep.
Thank you, Matt.
Great questions. Great questions. Thanks for calling in tonight. Anybody else have a question? It's 9:50. And so far we've had two really good questions, lots of questions from two callers. Star 8, folks, on your phone, hit star 8. Right now we don't have anybody, so if we don't have any takers, we may decide to end early tonight.
Hey, we scared them all away?
No, I think they're trying to absorb all this new information that we just gave them, Christian.
Well, the best
here
way
we
to
go.
do that is to take the Black's Law Dictionary and go over these strange words that are in this treatise and study those definitions and then get them down. Because you're really going to need to understand.
Got a caller from South Nevada. Go ahead, you've been unmuted.
Yeah, this is on TalkShoe, right?
Yes, that is correct.
I tried to log on that code 41875. It came back as not.
That's because we're not a publicly broadcasted call. It's private, invitation only.
Oh, is it? Okay.
Yep, but you should still be able to get to the link. Are you a member of the Free Americans Yahoo group?
No, I'm not.
Okay, because we send out an invite every week, and in that invite there's a URL that you can click on, and that'll take you right to the TalkShoe web page that shows all of the recordings for the last year and a half.
And that's under Free Americans?
Yep, if you go to groups.yahoo.com that's groups, plural, groups.yahoo.com/group/the-free-Americans, and hit enter. That'll bring you to the page, and then you can just click on membership and go through the process of becoming a member.
Oh, okay.
And then you can look at the messages, and I send out a message reminder every week. I post a message for our group on Wednesday nights at 8 p.m. Eastern. And in that message, there is a link that you can click on. That'll take you right to the TalkShoe page. So you can download the questions. Go ahead with the question.
So that's groups.yahoo or groups?
.yahoo.com.
.yahoo.com/group/the-free-Americans.
That's correct, yep.
Okay, thank you.
Thanks for the question. Next caller, Sagita. Did I say that right?
Hello.
Hello, thanks for the call.
I wanted to ask Christian if he might know something about the letter of marquee reprisal. And is it possible to harness that?
Why do you want to use it?
I don't want to use it, but this is exactly what public officials have to use on you. And I'm wondering, is there something we can do to defang it?
Yes, take yourself along with all your assets and move it into trust. That puts it outside their realm, outside their jurisdiction, and they can't touch it.
Okay. And how are we doing this?
We're trying to claim the master trust and terminate it and form the new trust and totally make everything private, and we're going to interface back in such a way that we're not effectively connected with doing business or trade, and we're not tied in with the jurisdiction.
Okay, well, we've been kind of sort of trying to do this for quite some time now.
I know, but we've been doing it under debtor creditor, and it just doesn't work that way.
Right, I understand. But I just recently became aware of this monster, and I didn't realize that that's what they all have.
Yeah, it's the Admiralty Enterprise, yes.
Wow.
You're just flotsam and jetsam.
Yeah, it is. But anyway, it's a pretty powerful thing.
Yes, it is, but it's really under misconstruement because they're not the sovereigns. So they can't have any letters of marque because we didn't grant them. Or if we did grant them, we need to be calling them back.
Yeah, how do we do that?
Well, let's go into the assumption that we did grant them.
Okay.
Demand the surrender of the letter of marque back.
That's a good idea.
Well, let's go under the assumption that, okay, in a court scenario, the judge is wanting your name. He's going to take your name under the letter of marque rule.
And that's what they're doing.
All right. Your Honor, I am the trustee on this trust. I do not have to disclose who the beneficiary is, but I know who the beneficiary is. And the beneficiary is not you. Therefore, I did not grant you the right to take as beneficiary. You do not have that right. It was not granted by me or the grantor. Why don't we try some of that?
That sounds like a good one. Do you suppose there's something that we can send to them in writing? Or is that putting your feet in it?
Yeah, you could send that in writing to them, yes. Yeah. If I was the grantor and the trustor in one and the same, then if I'm coming into court, they want to see me being trustee. All right, I'll be trustee, but as trustee and also grantor, I have the knowledge that judge or anybody else, you guys are not beneficiaries because I'm the grantor on the trust, and I didn't delegate, I didn't grant you that authority.
Okay.
I'm here to set the misconstruement as a mistake and set it right the other way. You don't have the right to take my name. Although I can give you my name in confidence for a special deposit to be returned to me in kind, and I'm going to rely on that. And then I want the proceeds and all from my signature or the granting of my name to be returned to me in kind. And I could specify for the payment of whatever debt they're claiming. So really, I think we really have all the power, just like Dorothy in The Wizard of Oz. You know,
right.
She's wearing the slippers all through the movie, had the power to go home at any time. It was only till the end of the movie when the good witch told her, well, you know, you had the power all along, except if I would have told you, you would have never believed me. It's when you believe you have it based on knowledge and understanding that really the remedy, it keeps on saying, you know, there's no remedy at law. I don't know how many people I've heard that, and it really, it's just not till recently did that really take on a new meaning to me. And it was really when I was reading through with Lewin here, and it just hit me. Because I remember putting temporary restraining orders together, and one of the elements under the temporary restraining order was the element there had to be no adequate remedy at law. There is no adequate remedy at law on the at-law side in the courts. It's only through equity.
Oh.
And equity is the sole jurisdiction where trusts are. So the remedy is not in at-law side. The remedy is on equity side through trust. So I think it's getting the knowledge down of the parties of the trust, what their duties, responsibilities, what their powers are, the positions, the elements necessary for the trust, and methods for formation. And then reading this stuff like this Lewin that's, pretty cut and dried and kind of tough to get through and chew on for a while, but then, it's just like a dry, parched land. When it rains, the rain doesn't soak in right away. It's like sits there on top, still gets soaked in, and then eventually it gets into the ground.
Right.
And the more that we study this stuff, the more understanding we're going to get. And as we stick with it, it grows exponentially.
Yes, I'm beginning to see that we need to look at everything in trust eyes.
Yeah, we need to go back and rethink everything that we thought we knew and look at it under trust eyes.
That's the rub, is having to go back and rethink everything, because everything has been alive.
Page 17 I read today on Lewin. It said number 6 under page 17. It says, no remedy of the Seti Key Trust but in Chancery. The Seti Key Trust has no remedy, and that's at law, but by a subpoena in Chancery. So it's got to be by a subpoena, a counterclaim, summons. And then a footnote, it gives, the remedy must be in equity. Did you realize what they're telling us here? right here. The remedy must be in equity, number 1, on the footnote. The action is to be brought in the name of the trustee. And down farther, it says the trustee or his grantee may protect his legal title against a suit at law. That's on the other side. By the Seti Key Trust. And it says a bill in equity, which is the breach of the claim really, or bill in Chancery, a bill in equity may be maintained to establish a trust. A bill in equity may be maintained to establish a trust, where the jurisdiction over an alleged trustee is likely to terminate. And
so that Seti Key Trust then is a trust.
Yes, but we've been saying there's a Seti Key Trust, but then he who claims trust must prove trust. And I just read in Corpus Juris Secundum a couple nights ago that it said that if you make reference to a trust, it must be treated as a trust. Otherwise, you can't get remedy unless it is treated as a trust, what we're reading right here now. We've been sitting here spinning our wheels for years and 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 years, thinking we're going to get a remedy, and there's no way possible you can get a remedy except in trust under equity. So a suit may be brought by a trustee, which he would be estopped to bring in an individual capacity at the end there. But anyway, check out page 17 there, number 6, and see the footnote number 1.
Okay. Will do.
That's really how to claim trust and get into equity by subpoena, for there is no adequate remedy at law but in equity.
Tricky stuff.
Anything else?
That's the answer to my question. Thank you.
All right. Thank you so much for the question. Folks, thanks for joining us tonight. We're going to go ahead and wrap up the call for tonight, but we will be back again next Wednesday at 8 o'clock Eastern Time to continue our discussion with our new book that we're going through, the treatise. I did send that link out. I'll also put it on the Yahoo groups, the Free Americans, so you can go out there and grab the link from there as well. I changed it to a tiny URL, so it's a lot smaller. You can click on it, and that'll get you out there. I found volumes 1 and 2. Have a great evening, folks. Christian, thank you again. And
all right.
We will talk at you next week.
Thanks.
Good night, everybody.